Hello everyone, welcome to CIPPE training by the Tech Seeker, and today we are going to discuss in our lecture number 2 one important concept, that is your personal data, the definition and the concept of personal data. Now, if you see, Article 4.1 of the GDPR provides that the definition of the personal data, which is personal data means any information relating to or to an identified or identifiable person, natural person, that is a data subject over here. Okay, so if there is any information which is relating to an identified or identifiable natural person, that may become your personal data. Now there are four elements. If we break down this definition, there are four elements. Number one, any information. Number two, relating to, the concept of relation. Number three, identified or fiable, not necessary that is it is already identified. And fourth is the natural person. Now let's us understand each of the element in detail and why it is necessary. Because once we understand all the elements, we will be able to understand what personal data is, and based on that we will be able to understand to which personal data the GDPR is applicable. So it is very important to understand the elements of the personal data. Also, we will go through the GDPR text to understand in detail that how and where what is given. Okay, so let's go to the GDPR text. Now, if you see in the GDPR text, the definition that I was talking about of personal data is given in the Article 4.1. So let's go to the Article 4.1. Okay, and here we are with respect to the Article 4, which is of the definition. So if you see, Article 4 talks about definitions, and if you see 4.1, it is personal data. Now this personal data, again we will go to the definition and we'll read once again. That is, personal data means we will bifurcate the elements: any information, then relating to, then an identified or identifiable, and the last element is your natural person, which is the data subject. Okay, so that is the definition of personal data which is given in the definitions Article 4.1. Now if you see, we have discussed these four elements in summary. Now if we see each element in detail, we will understand how wide interpretation is there for the definition of personal data. Okay, let's go back to our presentation. Now let's go to the first and foremost element of the personal data definition, which is any information. Okay, so the first element is any information. Now the term any information was also there in the directives, is also there in the GDPR. When we interpret the term any information, we have to interpret in a broader way, in a broader concept. Any information means any information, literal any information. That is your name, ID, address, phone number, email, medical records, IP address, RFID, cookie ID, any information. Okay, so the term any information has to be interpreted in a broader concept. Number two, the personal data, like the any information which is personal data, not necessary that it has to be proven true. For example, you have my name, you have my ID, you have my address, but the address is incorrect. Whether the question is that whether the incorrect address is not a personal data, the answer is no. Incorrect address is also a personal data because the term any information includes correct and incorrect information both. Now, when I say incorrect information, means information which was assumed to be correct by the data controller. We will see who is the data controller, who are the data processors, but as of now, just park it on the side and see, understand that when I talk about personal data or any information element of the personal data, it can be correct or it can be incorrect also. Now, the personal data is not only related to the private life of a data subject. Personal data can be related to the professional or the business, activities of the data subject. Now, that was explained and that was discussed in a very important case of the judgment of the European Court of Human Rights in the case of Aman versus Switzerland. It is of 2000. Now, over there, the term private life was not interpreted restrictively. Rather, they interpreted that private life includes a lot of things. Okay, so it has to be interpreted in a broader concepts. So that's why the individual's private life or the family life is not only the thing that is required to be considered for the personal data, but private life will include the working relationship, economic and social behavior of that individual, that may include his business related details. So the term private life or the term personal data or any information element of the personal data has to be interpreted in a wider way. We have a very good example. For example, if you see professional habits and the practice drugs prescription information, that is drug identification number, drug name, drug strength, manufacturer, selling price, new refill, reason for reuse, reason for no substitution, order, prescriber's first and last name, phone number, etc., whether in the form of individual prescription or in the form of a pattern, okay, that is giving information or that is becoming information about like the physician who has prescribed the drug, or something about the patient, that pattern is providing some information about that patient which is anonymous, okay, as of now not known. Still it can be concluded as a personal data. Still it can be concluded as a personal data if like providing the information about prescription, and if I provide you the information about doctor, and from that you can somehow draw the understanding like about whom it is being talked, about whom it could be. Yes, it's a personal data. We will come to the other elements, but as of now understand that personal data is a very big term. Any information makes that personal data term wider, larger, and that's the intent of the legislation. Now let's understand the second element, which is relating to. Now, when I talk about relating to, it is relating to the information and the individual. It is the connection between the individual and the information. Okay. Now, there are three major principles through which we need to understand this connection. One is the content, one is a purpose, and one is a result. Okay. These three elements develop that relationship between the any information and that individual, which could be identified or identifiable. Okay. Now when I can say these elements are present, okay, the content means the information itself. So when the information is about that particular identifiable individual, okay, the content, any information which is there, okay, is about that in particular individual, you can say that there is a relationship relating to. Number two, that any information is used for certain purpose which may be for the identification of that natural person. So if you are using that any information for the purpose of identifying, or you want to identify a natural person by using that particular information, the purpose criteria gets satisfied. In that case, any information becomes related to the individual. So if by using that any information, if you are able to identify a person, that is related to, that creates a relation to that individual. And third is the result, the impact or outcome on the individual. Now if, let's say for example, there is a personal data, medical related records of a particular person. Okay, now if those medical related records of the particular person are available with a data controller, as of now park it like what is a data controller, but understand that a person who is processing the data, like collector of data. So let's say that the data, medical data, is with the collectors of the data, and that medical data is being used by that collector in certain way, which is also impacting the individual about whom the medical data is. In that case, you can say that result is creating a relationship between the information and the individual. If any of the element is present, for example content, purpose, result, in that case you can say that there is a relation between the any information and your personal data of that particular identified or identifiable person. So the connection established between the information and the person, which can be identified or which is already identified. For example, the value of a house. Okay, the value of a particular house is the information about an object. It's not in personal data. But if you use that information, okay, if you use that information to determine a person's obligation to pay some taxes, for example wealth tax or some house property tax, in that case that particular information, with the help of purpose element, I can say is a personal information, personal data. Same, for example, okay, the service register of a car held by a mechanic or garage contains information about the car: mileage, dates of service, technical problem, material condition. Now if the information with the plate number and engine number, which in turn be linked to the owner, is recorded in that register, that becomes the content through which you can identify the person, and that creates a content link relating to. Now for example, where a garage tries to establish a connection between the vehicle owner and the billing information, for example for the purpose of, okay, which car he has, since when he is having that car, or for xyz person reason, he is trying to establish the connection between the vehicle and the owner. In that case, the purpose, or you can say the element of the purpose, will come into the picture, and it will create a relationship between the information, that is the car information, and the owner, that is identifiable or identified person. Okay, so through these examples you can understand the element of content, purpose and result, which is creating a relationship. That was our second element. Now we will proceed to our third and important element. Now let us go to our third element, that is an identified or identifiable natural person. Okay, so the natural person we are talking about here, the natural person. Now whether it is identified or identifiable, the important part here is that identifiable, the suffix able, that means not necessary the person has been identified yet. if it is possible to identify the person through the data which is yet to be identified, still that particular information will help and will constitute as a personal data. So that means if through that particular any information you create a link between a person, or whether that you are able to create a link with that particular person, or you are able to attach a link to a person, as of now we don't know who that person is, but if you are able to do that, or if you have a capacity to do that, in that case you can say that the person is identifiable through that information, and that any information will become your personal data. Okay, so not necessarily identified, it could be identifiable. Now, is it necessary that I need to identify the person physically? Answer is no. And the details are given in your recital 30. Recital 30 says that natural person may be associated with online identifiers provided by their device. Okay, applications, tools, protocols, or something like that. That if you can identify that a natural person online, not necessarily physically but online also. Let's say for example I have a bunch of IDs, IP addresses, and if I am able to tag, okay, this is a person who visited my website, means this is the IP address who visited my website, that is also creating a relationship. So online identifiers, that is IP address, is sufficient to link with a identifiable person, and that will create your personal data. It's not necessary that you need to locate the person, or you will be able to locate the person physically. No, it is important that you can identify the person online, physical, anywhere, or you have a capacity to identify or distinguish a person from a group. In that case, yes, it will become a personal data. For this, we will understand one very important judgment, that is Patrick Briers versus Deutschland. Here we will understand the intent of the EU legislature and how they have interpreted the word indirectly. So we will understand the word indirectly over here. So you can either identify that person directly or indirectly. In order to understand the word indirectly, they interpreted the term indirectly in a larger context. That means if you are able to identify the said person through a dynamic IP address registered by an online media service provider, when the person accesses that website, yes, that will constitute a personal data, and that information, that IP address, is any information which is creating a link to any person. As of now, do we know who that person is? Answer is no. But can we distinguish that person from the group of persons? Yes, we can differentiate through the IP address. But who is behind that IP address? We don't know. But if we are able to distinguish through that IP address, that means he is identifiable, that means that IP address is any information, that means there is a relation, and that becomes your personal data. Here we need to understand a very important concept, pseudonymization. Now what is this? It is the processing of personal data in a manner that you cannot relate that personal data to specific data subject or that specific natural person. For example, you have the car numbers, okay, or let's say you have the service record of the car, and you have the name of the owner of the car, you have the car number. Now let's say for example you break that data, you divide that data in two different tables. Service record, like which car model number was serviced when, at what kilometers, and the number plate and the name in a separate table. The service table is separate. Now there is a common identifier between both of them. For example, you have given car number 1. So car number one, model this, serviced this many times, this date. So this is a one table. Now in another table, you have a car number one, then you have a kind of name of the owner of the car, and then you have a car number plate. So as of now, if I see only table number one, where the car service details are there, I cannot identify who the owner is, or I cannot relate that particular service information to any of the natural person. In that case, I can say that I have pseudonymized the data, and hence it is no longer a personal data for now. But if I have both of the tables together, that means I am in the access, or I have the access to the second table, or I can get access to the second table somehow, so that I can in future link both of the tables and I can get the information. In that case, I would say that table number will one will be the personal data. Now we will see one more recital from the GDPR itself, which is very important to understand the third element, that is recital number 26. Now, what recital 26 says that it's a very detailed one. It talks about two important aspects. One is about the information. Second is about the identification of the natural person. Now, if you read the recital 26, it says that the principle of data protection should apply to any information. So it says, it talks about the content first. Okay, it applies to any information. Now, if you read further in the recital, you will come to know it says that to ascertain whether means are likely to be used to identify the natural person. So, the purpose I'm talking about over here. Remember the purpose, the content, and the result element of the relationship. Now, over we are talking about the purpose. If you are going to use that information to identify the natural person, and if I say that okay, there are means available, or there is a high chances that there are the means available. Okay, in that case, I could say that the information relates to that particular identified or identifiable natural person. Recital 26 also places an important focus on the objective factors that are there for the identification for that natural person. For example, the time, the cost involved in the identification, the technology involved. So we need to consider that when I say identifiable, at what cost? Identifiable at what technology? By using what technology? So we need to consider the objective factors when we say yes, it is identifiable, but the factors, the objective factors should be there. Okay, within the reasonable cost, within the reasonable amount of time, within the reasonable given technology, it is possible. Then yes, I could say it is identifiable. Otherwise, I cannot say it is identifiable. So, two important aspects from recital 26. Number one, it talks about the content, that any information, it talks about the purpose. Number two, it talks about the objective factors. Okay, that we need to undertake, we need to think of before we can say that yes, the person is identifiable directly or indirectly. Okay, so that is also given in your recital 26, that to determine whether a natural person is identifiable, account should be taken of the all means reasonably likely to be used, such as singling out either by the controller or by any person to identify the natural person directly or indirectly. Okay, so that is your very important recital 26, which plays an focus on information, content, that is, and the purpose. Number two, it talks about the objective factor, and number three talks about directly indirectly identification both. Now we will move to our last element and very important element, which is your natural person. Element number 4, natural person. Now natural person is not defined in GDPR. It's not there in the article 4.1. But if you want to understand natural person, we need to take a support from other recitals and articles. For example, Article 3, okay, one of the like sub article in the Article 3 talks about that regulation applies to the processing of personal data of data subject who are in the union. So first of all, we are talking about data subjects who are in the union. Number two, if you see the recital 27, it says that it does not apply to the personal data, processing of personal data of the person who are no longer there. If they have died, okay, if you process the personal data of that person who is already, dead, in that case, this particular regulation will not be applicable to them. So only living person should be considered for this particular regulation. When I say living, okay, that means we are again talking about natural person, not a legal person, and that is further clarified by the recital 14, that it of the regulation or the protection under this regulation should apply only to natural person, whatever their nationality or place of residence is. This regulation does not cover the processing of personal data which concerns the legal person. For example, company, for example, LLCs, for example, any other legal form that is there across the union. To them, this particular regulation will not be applicable. But if there is a natural person, a human we are talking about, living human, in that case, this particular regulation or the protection under this regulation will be applicable to that. Again, the same things are there for the recital 23, recital 18. They validate the same understanding about the natural person. So the fourth element is natural person, not a legal person, not a deed person, but it's a natural living person we are talking about. So these are the four critical elements of the definition of personal data. Now we'll go back and we will read the definition again. Personal data means any information relating to an identified or identifiable natural person. In that case, it will be personal data. Okay, so we have now understood the four elements. Now we are able to distinguish the personal data from other information. Okay, so this is how you need to interpret the definition of personal data. Plus, Article 4.1 also specifically says that an identified natural person is the one who can be identified directly, indirectly, in particular reference to such and certain identifiers. For example, name, identification number, location data, online identifiers. So all these things are required to be considered for identification of a natural person. Okay, let's see a quick summary of this particular article.
Let's quickly summarize the session. The concept of personal data is the gateway to the application of the General Data Protection Regulation, GDPR. If the information being processed does not qualify as personal data, the regulation's extensive rules on processing, security, and data subject rights do not apply. Therefore, a precise understanding of this term is the most critical foundation for any data protection professional. The GDPR defines personal data in Article 4.1 as any information relating to an identified or identifiable natural person, data subject. Let's break down the key components of this definition. First element, any information. This phrase signals an extremely broad scope. It is technology neutral and all-encompassing. Personal data is not limited to a name or an email address. It can be objective information, like a date of birth, or subjective information, like an opinion in a performance review. It can also include online identifiers such as IP addresses, cookie identifiers, and device IDs. Second element, relating to. The information must be about an individual. A piece of data can relate to a person directly, or it can do so indirectly if it is used to evaluate, treat, or influence their status or behavior. Third element, identified or identifiable natural person. This is the heart of the definition. An identified person is one who is named or otherwise distinguished from all other people. An identifiable person is one who can be identified, directly or indirectly, by reference to an identifier. The regulation clarifies that to determine whether a person is identifiable, one should take into account all the means reasonably likely to be used by the controller or any other person to identify that individual. This requires a practical, risk-based assessment. Not all data carries the same level of risk. The GDPR makes a critical distinction between data that has been pseudonymized and data that has been truly anonymized. Anonymous data. Data is anonymous if all personal identifiers have been irreversibly stripped away, making it impossible to identify the individual to whom it once related. If data is truly and effectively anonymized, it ceases to be personal data, and the GDPR no longer applies. However, the standard for true anonymization is very high. If the means to re-identify the individuals still exist, the data is not anonymous. Example, aggregated statistical data, such as 70% of our customers are based in France, is anonymous data, as no single individual can be identified. Pseudonymous data. Pseudonymization is defined in Article 4(5) as the processing of personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information. Crucially, this additional information must be kept separately and be subject to technical and organizational measures to ensure the personal data cannot be attributed to an identified or identifiable person. Pseudonymization is a security measure, not an exemption from the GDPR. The data remains personal data because the potential for re-identification exists. The regulation explicitly encourages pseudonymization as a method of reducing risks to data subjects and as a key component of data protection by design. Thank you for watching the lecture. In case of any doubt, you can reach out the faculty CA Harshad Tekwani at harshad.tekwani@hstassureadvisors.com.